Good afternoon. I'm Alison Baker at Venable. Welcome to Administrative Law and our regulatory update this afternoon. We're going to be talking about a number of issues that continue to percolate in the administrative law space, and we're joined by a really fantastic group of attorneys who I work with, and I'd like them all to go around and introduce themselves. We have John, if you can start us off, please.
I'm John Cooney. I come to this business after 40 years of representing clients and negotiating rules with agencies and in defending enforcement actions and in challenging rules in court when they don't work out so well. And the last year I was head of the American Bar Association section on administrative law.
I'm George Castellampros. I'm a partner in the Investigations and White Collar Practice Group here at Venable. My experience has been on SEC enforcement as well as Department of Justice investigations, Attorney General's investigations. The past several years, I've been involved in a case that has made its way up to the D.C. Circuit, and one of the issues raised was in the Lucia case about the appointment clause argument, and have a lot of experience in the administrative forum at the SEC.
My name is Monika Upadhyaya. I'm a partner at Venable in the commercial litigation group. I was on the administrative law review as a staff member, and that is the official publication of the section that John headed. I clerked on the U.S. District Court for the District of Columbia at a time of many, many challenges to administrative regulations, particularly to the Dodd-Frank Wall Street Reform Act, and handled a number of matters as a clerk. After going back into private practice, I've handled at least about a dozen of the administrative challenges in the U.S. District Court for the District of Columbia and the D.C. Circuit in the past 3 years or so.
My name is Sheikh, and I'm a fifth-year associate here at Venable in the commercial litigation group. I have the good honor of working with so many of the partners that I share the panel with. But some of my work has focused on, in the last couple of years, on administrative law, working on challenges that pertain to various departments on behalf of various clients, as well as in the pro bono sphere, working with Mr. Cooney in drafting and submitting briefs related to the DACA litigation.
And good afternoon. I'm Alison Baker. I'm a partner in the litigation and consumer financial services practice here at Venable. And my practice in the last 3, 4, 5 years has focused a lot on agency practice, both litigation at the agency level as well as challenges to agency determinations in the district courts and in the circuit courts. And as we are starting today, I want to just a few housekeeping matters. First of all, there will be CLE offered for today's webinar, so please stay tuned. At the very end of the program today, a code will be sent out through our question and answer chat feature. Speaking of which, you should feel free at any point in time to send in a question, and it will be directed to us, and we'll have an opportunity to throw it out to the panelists for an answer. And in addition, after today's presentation, this entire presentation will be available on our website should you choose to download it. In addition, if at any point in time subsequent to this presentation you have additional questions, you can also email us. So I want to start off today with a question for our panelists. When Donald Trump came into office in January of 2017, there was a lot of discussion about the status of the so-called administrative state, the way that regulatory agencies would go forward in their rulemaking and the relative roles they would continue to play in the federal government. And I think a lot of us, common wisdom, kind of told us that there would be a demise in the power of the so-called administrative state. You saw that certainly with Justice Gorsuch's nomination. That was one of his calling cards when he went before the Congress. And I'm curious if our panelists believe that that has in fact happened in the last couple of years. We're starting in next month. It will be the end of the second year of the Trump administration, and we will be starting to see, I think, the results of some efforts to roll back regulations and or challenge administrative rulemakings and or challenge the role more generally of the administrative state. And I'd like to start with John, who's been in this world for a number of years now, and get your perspective.
The The basic conclusion after the first 2 years is that the administration has a lot of initiatives underway, but many of them have not come to fruition yet, or are a good way still away from fruition, in part because of the lack of confirmed officials running parts of the executive branch, but also in other respects because it's just very hard to have a deregulatory agenda. It takes a long time to undo rules, and they may not have appreciated that when they first came into office. What you can say with a high degree of certainty is that the administration essentially has stopped issuing any new major rules. There was just a handful that managed to come out in the first year. I haven't seen the number for this year, but there are not many that have actually made it to the final rule stage. There are a couple reasons for that. One, the administration has set up a regulatory budget that discourages agencies from issuing new rules. Second factor is the Obama administration essentially cleaned out all the underbrush and the backlog. They got a large number of rules out the door right at the end. So there were not that many carryover rules waiting from President Trump's predecessors to be cleared out. And another reason is that there have been very few new statutes passed by Congress that would require agencies to start issuing new rules. The Dodd-Frank amendments are probably one of the few that fall into that category. So there have been very few new rules issued. Another thing you can say with a high degree of certainty is that the enforcement of existing rules has diminished significantly in various agencies under the Trump administration. There was a long article in the Washington Post this morning about the Consumer Financial Protection Bureau and what they've been doing, which is probably the longest analysis I've seen of what an agency has done comprehensively. A third thing that the administration has done that it never takes credit for and has received almost no press is that they reviewed a lot of Obama rules and they decided that they actually agreed with the policy, or if they disagreed with the policy, it was not significant enough to justify the time and effort that would be required to go back and try to adopt a deregulatory rule in that space. And then finally, what you can say is that the administration hurt itself in the effort to try to get new deregulatory rules in place by going at it too aggressively at the beginning. The administration has been tagged out a significant number of times for having not followed the process required to establish a deregulatory rule, which in many events set them back 6 to 9 months. To date, there really are only 5 really significant rules that have made it to the notice of proposed rulemaking stage, and that might be ripe for coming to final rule that would be issued sometime in 2019. And those are, first and foremost, the corporate average fuel economy standards at DOT, which will govern whether the auto industry has to make continued increases in technology and increases in miles per gallon earned from 2020 to 2025. Second in significance is probably the Waters of the United States rule, which has been an open sore between the courts and EPA and the Corps of Engineers since the early 2000s. The administration is working hard to try to get that rule out the door, to be followed by an epic lawsuit that will bring up all the difficulties people have had trying to figure out how to deal with wetlands since the early 2000s. The third major rule was on the Clean Power Plant initiative to try to determine what to do for the dwindling but still significant number of coal-fired power plants in the country. The fourth major rule they have at the NPRM stage is emissions from fracking in the drilling process. And finally, there's the Energy Department's energy appliance efficiency standards. Those are really the 5 big rules that the administration has out the door in the NPRM stage yet. And it's when those rules start to get to the courts, when they're challenged after being finalized, that we're going to have an understanding as to how strict the courts are going to be on requiring the new administration to be able to justify a significant change in policy, given the administrative record that the Obama administration put together in many of these areas, that will make it very difficult for a new administration to try to change those, in part because the administration hasn't given itself the time or the money to try to redo the scientific studies that would be necessary in a number of these areas.
So Moxie, you often find yourself living in the District of D.C. and or D.C. Circuit in this space. What do you expect to see in the coming months if it comes to pass that some of these rules that John just described end up getting challenged in court? That's usually where they would be challenged, one of those courts.
Well, one thing I'll mention, just to take a step back, is that we talk about the fears or concerns, depending on where you're sitting, of what's going to happen to the administrative state under Trump. I think what we have to do is realize that there were a long series of decisions that came down in the D.C. Circuit prior to Trump being elected that struck down a number of significant rulemakings. And that this is really, if there are any rules that are struck down, it's not anything new. You started to see in 2010 a number of challenges that were all quite successful. George can tell you about some of the SEC investment advisor rules that were struck down in the D.C. Circuit. There was quite a significant position limits rule under the Commodity Futures Trading Commission that was struck down, and that trend went on for about 4 years prior to Trump even taking office. So what I expect to see is that the D.C. Circuit continues to be quite strict when it comes to agencies applying their mandate, following their so-called enabling statutes, or whatever the enabling statute is for that particular regulation. So I frankly don't see a lot of difference in the circuit's scrutiny. The question is going to be whether the agency phoned it in because they have an executive that may or may not be pushing a particular regulation, and if they didn't go through the processes of a rational review and a rational passing of the regulation. The D.C. Circuit, I don't see the D.C. Circuit being much different in how it scrutinizes these regulations. So I think we have to remember that we're dealing with a court that's extremely sophisticated in reviewing these regulations, and some jurists who've been there, some of whom are now in their senior status role, but who are quite known to be extremely difficult on the administrative state.
You know, one of the things I think is interesting, and I hear what you're saying, which is that courts don't necessarily change their mind or their analysis or their analytical roadmaps that they follow. They may build out a legal doctrine. But one of the interesting things that does happen in the mind's eye of folks who are either regulated, part of the regulated industry sector, or even just individuals, is their perception of the ability to challenge an agency changes. And so much of that, an agency's ability to regulate effectively comes from the perception of its own power, in addition to the actuality of its own power, but the perception, the ability to challenge, for example, in my space, the CFPB. If I'm a bank that's regulated by the Bureau, my appetite for challenging the Bureau might change depending on who runs it, and depending on the politics around that. And George, this is a world you live in as well, in the Securities and Exchange Commission space. And I wonder how your own practice, both in the courts but also in advising clients in the SEC world, is affected by a perception that the administrative state under Trump has either died a slow death or is dying a slow death, or maybe it isn't.
Look, I agree with Moxie and what she said about the courts, and really I think it's ultimately courts have been fairly consistent in basically requiring agencies to meet what they need to in issuing rules. But at the end of the day, I think we've seen it recently in the fiduciary rule where it was challenged, where the court struck it down, and the agency itself hasn't done anything to really follow up and press that rule. And that's where I think you see this. I mean, it's never going to be the death of the administrative state, obviously, but it's a slow growing old, let's just say. And I think part of that is because the agencies themselves, have new leadership under the guidance and direction of obviously President Trump, and they have their marching orders. And you're right, Alison. I think, now what I've seen is that, the SEC is not going away with its enforcement matters. They will always be there enforcing the securities laws. And the securities laws, they're not going to be changed. I mean, the SEC is not issuing any new rules, but at the end of the day, the SEC is still going to be out there prosecuting its bread and butter work. But one of the things that I have seen is because the SEC commissioners have almost fully changed now there's one holdover, there is a change in the mindset. Remember, for the SEC, Mary Jo White had come in and then had this policy of a broken windows policy, so no violation was too small to bring as an enforcement action. And I've seen that 180-degree turn at this point, where actions have been brought, same actions, but ultimately the penalties and remedies that have been sought have been something that has been much less. And I think that's where the arguments that our clients, if you're ever faced, or they're faced with an investigation or enforcement action, is to obviously defend it as best you can, but ultimately I think get the ear of the supervisors at the SEC as to what, number one, whether an enforcement action is proper, but then ultimately what can you settle to.
So, and I want to come back to the process of adjudicating matters in agencies in a moment, but one of the things that I kind of want to take a step back and talk briefly about is, why do we care about this question of the administrative state under Trump being robust or not robust? I mean, I think there's a lot of people kind of scratching their head and saying, does it really matter from a day-to-day perspective how we manage our business, how we think about our risk, how we manage our risk, how we project outward 2, 3, 4, 5 years when we're taking on new business units or bringing to market new types of products and services. And I'm curious about what you think about that, and I'd like to get your thoughts on that, George, as someone who works in an industry that is highly regulated, right, and has long been regulated and has had a lot of its actors in that space conduct their affairs around the fact of regulation, namely the SEC, but not only the SEC. And then, John, I'd love your perspective on that as somebody who's just lived in this world and has worked with a lot of different sectors of the economy as those companies and entities try to manage and think through risk. And George, why don't you start?
Yeah, look, I don't think it changes a company or an individual's, how they proceed at the end of the day in identifying risk and how they respond to that risk and potentially remediate that risk. It's not the point where you say, hey, look, you should take all the risk-taking that you can at this point because the risk of an exposure to an enforcement action is much less. And the reason for that is a number of reasons, right? The securities laws, all the securities laws, like I said earlier, but it's not the SEC out there only, or the federal government as an agency that's enforcing the laws. I mean, there are state agencies, there are SROs, self-regulatory agencies like FINRA. So the balance on what the risk is and how you respond to that risk should stay the same. Ultimately, I think it's on the backside when there ever is a hard look by an agency where you have more arguments to be made there as to why something was done, whether it was a violation of law, and then ultimately, if there is one, again, how do you resolve it?
I as you were talking, I was thinking the same thing, which is, in my space, the consumer financial services space, which is where I spend not all of my time, but much of my time, the CFPB's perceived lack of enforcement activity over the last year, and I think it's actually probably the case that there has been less activity. That mantle's been taken up by the states in a big way. And in some ways, there's fewer protocols around how states operate than there are around how the federal agencies operate. And John, I'd love your thoughts on that issue as well. I mean, both what you see in terms of managing risk in light of people trying to game out the role of the administrative state in this administration, and then even if that administrative state is seen as waning, you've got states waiting in the wings to take up the mantle.
What I found is that the Trump administration agencies have spent the first 2 years working hard and have found out how incredibly difficult it is to put through a deregulatory rule. It's really difficult on procedure, it's really difficult on the science, and it's very difficult within the rulemaking process itself, by which I mean the world is a very complicated place. There is no such thing as a monolithic industry. Within an industry, there are many different business models, and the regulations were drafted in the first place to take into account the many differences in the entities that were going to be subject to regulation. The most famous of those in Washington these days is probably the difference between big banks and little banks, and the economies of scale that there are to responding to regulations, and how difficult it has been to try to work out that balance. But that's one example of something that's found in almost every significant rule. Another phenomenon that they have figured out is that there is intense competition among people who are being regulated. The administration has been surprised many times in many different agencies by the basic fact that if a rule has been adopted, a certain number of people will go ahead and comply with it very early on. They figured it was in their long-term economic self-interest to do that. The classic example of that under Trump is the number of coal-fired utility plants that were retired. The second Obama head of EPA was a flat-out genius, in my estimation, for understanding this aspect of competition among firms, and she gave entities real help on the backside on what they're going to have to do to dismantle plants and the monitoring after the fact. If they would make a public commitment almost immediately after the adoption of the rule that they would retire their coal-fired power plants. And the boards of directors knew that they were going to end up retiring these plants sooner or later because the economic incentive to shift to natural gas as a fuel was so strong. So they went ahead and announced early on that they were going to be retiring coal-fired power plants. And this all came to a head in 2015, really. You could see it coming in the Michigan v. EPA case, which was the closest the Supreme Court has ever come to requiring that there be cost-benefit analyses. And the amicus briefs in that case basically said, why are you even thinking about knocking down this rule? 75% of the changes already necessary to implement the rule have been done. Companies committed to these things early. The effort to get a stay of the rule pending appeal was denied, and so most of the changes have been made. What you have left now are who haven't made these changes were sort of, the less well-financed groups, or the ones who knew that they were going to be dismantling the facility anyway and were just going to let it decline slowly and then go as long as they can before they had to take it out of existence. And the people who were raising these objections were, in many cases, the established parts of the industry. And you can see this in comments that have been made about anti-money laundering controls within the banking industry. It turned out that there were efficiencies in management from having put those controls into place, and the entities that had made the huge capital allocations necessary to put those in place were not thrilled at the thought that people who'd played along and not made the investments would get a competitive advantage over them that way. So all of those factors, Alison, complicate the risk analysis in determining what you want to do in a situation. It all depends upon where the company stands, its own understanding of when it's going to have to phase out or replace its controls, and the risk that they're willing to take that they can get those things retired before they have an enforcement action for not following the current Obama rule, and how much they have to gain from investing the resources in and supporting a dereg of those rules, the Obama rules that are now in place.
You make a really interesting and thoughtful point about sometimes there are counterintuitive parties who don't, it's counterintuitive sometimes that certain parties don't necessarily support getting rid of an agency's rule or even an agency because of the level playing field issue. And they feel like, we made a huge capital investment under the last administration. We see this a lot in the financial services space, with a lot of the rules that came in under Cordray at the CFPB, for example. We made a huge investment in coming into compliance with certain rules, for example, having to do with the TILA-RESPA Integrated Disclosure Act for mortgages. And now you're telling us that this wants that you want to do this or you want to do that, and you hear a lot of conversation about that from people. TRID is probably not a great example because actually that hasn't really been as controversial as some other rules, but it's a really interesting point, and it complicates this narrative a little bit. George, I want to talk to you a bit about the issue of adjudicating cases in the administrative agency forum specifically, and we had this Supreme Court case, Lucia, that came down that functionally invalidated the way that the Securities and Exchange Commission had appointed its administrative law judges. A lot of us are scratching our heads, though, about what it actually means, because the case really, it kind of goes like 65% of the way there and then stops short. And no one's quite clear as to what that means in terms of, are these agency actions pre-Lucia invalidated? Are they susceptible to appeal to the D.C. Circuit or to other circuits? And I know you're like squarely in the middle of this. So can you give us a little bit of a sense of how this is playing itself out in your world and maybe others like it?
Sure. Right. So the Supreme Court had come down in June of this year in the Lucia case. And in the Lucia case, just for those who aren't aware of it, that's a case where the SEC brought in an administrative enforcement action against an investment advisor and its principal, asserting all sorts of claims, fraud claims, and the action was tried before an administrative judge at the SEC. Not unsurprisingly, was the fact that the advisor lost at the SEC's forum, which, by the way, has an over 90% win record, as opposed to in federal court, where the SEC could have brought this case as well, where their win record is in the 60% percentile. So the respondent there, the investment advisor, appealed it to the SEC, the full commission, lost there. Again, that's not surprising at all, and ultimately brought challenge before the D.C. Circuit. One of the issues that the respondent brought up was the fact that the ALJ was not appointed properly under the Appointments Clause of the Constitution. Thus, the underlying proceedings were invalid. The D.C. Circuit, their original three-judge panel, ruled against Lucia. Ultimately, the en banc court was divided evenly, and the Supreme Court took cert because there was a conflicting 10th Circuit decision called Bandemere. But Lucia had made a calculated decision all along the way that they would only raise the Appointment Clause argument. The Appointment Clause argument is an argument where you say, look, the ALJ is an inferior officer because they exercise basically substantial authority, executive authority. And the argument there is that the ALJ is, in effect, akin to a federal judge, takes in evidence, rules on evidence, ultimately is the fact finder, and issues a ruling that in many instances, in almost all cases, the SEC adopts in one way or another. The Supreme Court came down and again, narrowly found that yes, there was an Appointments Clause violation, and the ruling applies to essentially, the way that I view it, almost all ALJs in the federal court system except for Social Security administrative judges. And it needs to be stated too that the majority of ALJs are Social Security administrative judges. So it's the ALJs that are able to rule on adversary proceedings, alleging violations of the law. So what's left here? You're right. I mean, what did Lucia get out of it? Lucia got...
the head scratcher.
You're right. You just spent millions of dollars fighting all the way through the administrative forum and all the way up to the D.C. Circuit. And now what you get is a new hearing before a new ALJ. Not really much of a victory ultimately at the end of the day. But there are arguments that now still remain. And one of those arguments is the separation of powers challenge, which was a key issue before the D.C. Circuit, and a key issue that Justice Breyer, in his opinion, in Lucia, his concurring dissenting opinion and dissenting opinion in part, in Lucia raised that, look, if the ALJ is an inferior officer, then that just leads us into the separation of powers argument. And that argument is that the ALJs enjoy 2 layers of tenure protection. What that means is they cannot be fired without good cause, and the only people who can make that determination are the commissioners themselves and the MSPB, the Merit Systems Protection Board. All of those individuals enjoy good cause protection as well, removal protection. And the Supreme Court precedent to date has said, look, if there's 2 layers of protection, removal protection, then that's too far removed from the president in his role as the executive, and therefore it's a separation of powers issue. This is the real key issue, I think, in these cases, because it gets to the heart of the administrative state in the sense of administrative enforcement actions and administrative adjudications. It takes a stab at the APA itself. And the APA was meant to have some independence and offer some independence and impartiality, and just through the process of an administrative adjudication. Now, having been through a number of administrative trials, I'd go far as to say, look, this notion that ALJs are impartial is just a farce at the end of the day. Look at I always give this example is if the SEC brought a case in federal court as the defendant, you'd have a right to move to dismiss that complaint. You'd get before a federal judge, and the federal judge would then look at the briefing and make his or her decision. What you're asking, you have the same process in the SEC's forum. You can move for what's called motion for summary disposition. But you're basically asking the ALJ to decide that the commission who just approved this action, there wasn't enough facts there alleged to bring it. There's no way an ALJ is going to rule in that favor. And there's a line of precedent that the ALJs are going to follow that the commissioners themselves have issued. So look, at the end of the day, that may be fine under constitutional standards that the agency itself will be able to bring its cases in the administrative form. But ultimately, and I think John for later on will touch upon this, but what kind of deference should you give an administrative decision, the ALJ and ultimately the commissioners themselves? I mean, Samir, maybe you're going to touch upon that, but that's where I find is, okay, ultimately when you get before a court of appeals, what should that court of appeals, what kind of deference should it give to the agency in its underlying findings in an adversarial action?
Yeah, you bring up fantastic points. I too have litigated in the administrative agency forum, and it's markedly distinct from district court. The thing that just jumped out at me is the biggest distinction, and it's a huge distinction, is the importance of the rules of evidence and the mechanisms used to take in evidence, whether you're talking about written testimony or documents, the role that hearsay exceptions and lack of hearsay exceptions and lack of hearsay concerns, and things like that. All of those protocols aren't just niceties in district court. They are part of the due process clause of the Constitution, and they exist for a reason. And candidly, you don't see that same commitment at the administrative agency level, which has been part of what spurred a lot of these challenges to administrative adjudication in the D.C. Circuit and the Second Circuit. Judge Rakoff in the Southern District of New York has been quite vocal in his thoughts on that. You've seen it in the 11th Circuit and the Northern District of Georgia. But I think the place where it's mostly going to be considered and looked at on a go-forward is in the D.C. Circuit. And Moxie, I'm curious what you think about that, given your extensive experience with the Administrative Procedure Act, your involvement in cases that have been litigated in the circuit around these issues. On a go-forward, given the composition of the circuit and the likely composition with Kavanaugh being elevated and Rao coming in, most likely coming in, what is the circuit going to do in terms of deferring to not so much the rulemaking issues, but the findings that come out of these adjudicative proceedings, notwithstanding the issues around Lucia?
Well, the circuit starts with a presumption that the record is complete. That's at least the current law of the circuit. Okay, so if you're challenging whether the record is complete, you have an uphill battle, or traditionally that was the case. I don't see there being a huge shift in that general theory. And general standard actually is not theory, it's the standard of review if you're trying to challenge what's in the administrative record. I think where you're going to see possibly those who are trying to look behind the findings and to look to see if there are any errors in the way that the agency may have promulgated a rule is not maybe not necessarily just the findings, but taking a look at, as I said before, what the law enabling the regulation was. And you'll know that, or you'll learn that because the factual findings are what they are, one of the ways to really, if a court or a judge or a panel is really looking to strike down a rule, they're going to look and see whether the agency followed the legal mandate. That is the easiest way for you judges out there. You already know that. That's the easiest way for, and it's not easy, but it's the best kind of route to taking a look at whether the rule was even followed in accordance with its legal mandate. If the agency misinterpreted its authority, if the agency thought it had authority when it didn't have authority, or if the agency thought it was required to do something and did it when the law and the interpretation of the statute, as determined by the court, stated that if they didn't need to consider something, then you can go back to the drawing board. So I would think about it a little bit differently. I tend to think that the factual findings are what they are, but if you really want to make sure when you're going up on appeal that if you're on the challenging side of it, take a hard look at whether the agency misconstrued what it was allowed to do or what it was required to do.
So Samir, you're going to talk to us a bit about deference to agency rulemaking and guidance, which is a little bit of a different question than the one we're talking about now when we talk a little bit about Chevron deference, Skidmore deference. But you've recently and very successfully been part of a team of lawyers here at our firm who have litigated the DACA cases in, I think, the First Circuit, the Fifth Circuit, the Ninth Circuit. Am I right on those circuits? Maybe a couple of others thrown in. And a lot of the arguments you guys have been making have focused on the way that an agency thinks of its own rulemaking and some of the actions it takes in connection with its so-called legal mandate or lack of legal mandate. And I'm curious what your thoughts are about the ability to consistently challenge those ideas in different courts, not just the D.C. Circuit, where I don't think you guys have yet been.
That's right. And to the point of the D.C. Circuit, it's certainly one that's going to be taken up relatively soon in a case Microsoft and Princeton v. United States. The question you asked is a good one, and I think it goes to an earlier question, or an answer rather, that George gave about the importance of the administrative state and the level of reliance that people sort of give to rules promulgated by agencies, to the policies and the shifts in policies, the ways businesses make decisions around those policies. Similarly, individuals make decisions, life decisions, and that's where DACA has really sort of played on the role of the administrative state, the role of administrative law, the controls and policies and restrictions that are placed on the way in which rules may be entered as well as rules may be rescinded. In the case of the DACA litigation, the question was whether or not the rescission of the deferred action program would be treated in the same way that a rescission of a program or policy under any other administrative agency should be treated, and that people made reliance decisions, and the question of whether or not they made those investments in the belief that this certain rule or policy would exist and not be retracted or pulled away without any basis should affect, or should be found unconstitutional. These are the types of decisions, these are the types of questions that have been asked in the DACA litigation sphere, and I think they're ones that will be continued to ask as we look at how the administration deals with rules going forward.
So I wanted to come back a little bit to you, George, about some of the ways that we will be thinking about challenging administrative findings on a go-forward in the post-Lucia world. I know in my own work, we've looked at a lot of these issues, and we looked at these issues before Lucia, and this has been litigated in the Second Circuit and other places where there's an argument that, is it fair, for example, to try an individual in an administrative agency forum when that very same cause of action could be brought in federal district court? For those on the phone who may or may not know, For example, the Dodd-Frank Act gave the Securities and Exchange Commission's administrative agency forum the opportunity to bring cases in either district court or that forum. The Consumer Financial Protection Bureau's administrative agency forum is set up the same exact way. So Lucia, which challenges the SEC's appointment of ALJs, is extraordinarily applicable to the CFPB, or Bureau of Consumer Financial Protection, as well. And what's at the heart of a lot of those issues, apart and separate from the separation of powers issue, is, look, if I engage in conduct that's allegedly unlawful, and the CFPB or the SEC can pursue a case against me in the district court, or they can pursue the very same case against me in an administrative agency forum where there's no formal discovery proceedings and no federal rules of evidence and a very truncated expert discovery process and a truncated cross-examination process, how am I getting the benefits of equal protection or due process? And this is an issue, just off the cuff, George and I, we run into each other in the elevator bank and we talk about this issue. And I'm curious what your thoughts are right now on that point, as well as the post-Lucia issues that are going to be percolating up through the court system in the next year or two.
I think those are just all valid points. Look, you deprive a defendant or a respondent in the administrative forum of all the due process protections that you otherwise could have in federal court and are entitled to in federal court. Federal rules of evidence, number one. Federal rules of civil procedure, an Article III judge, a jury. Those are all rights that inherently we have, and those are just arbitrarily, in my view, arbitrarily taken away from you by what the agency has described as prosecutorial discretion. One thing that has changed recently at the SEC is that they're not bringing the amount of cases in their administrative forum. And frankly, what I've heard from the agency is that they've made a choice to bring those cases, the litigated cases, in federal court because, they know that there are concerns about the fairness of, not the fairness of being in the administrative forum, but these issues that have been raised. Ultimately, that is a change that could change again at some point. Who knows if the commission then has another change of heart. Ultimately, I think it's something that the courts need to hear and address. Is I view these as equal protection challenges and ultimately due process issues, right? The fact that the SEC and probably the CFPB now have allow for certain discovery at the end of the day, but ultimately, if the rules of evidence don't apply and you don't have an Article III judge there, I think your hands are tied, and it makes it much more difficult for you to have that record. And that's where ultimately I think, if you're before a federal, ultimately before a federal court after being through an administrative process, that court you're going to be in as the appellate court, is what kind of deference should be given to that underlying proceeding. And that's where I think the Trump administration and what the courts were doing before, and I think you'll see more of that, is taking a hard look at the underlying evidence. And that's something that I think most of us would say, look, you're never going to be able to challenge that in the appellate forum. But there have been some recent cases. There's a Lucetti case in the D.C. Circuit where Judge Kavanaugh issued the opinion and basically took the PCOB to task for depriving a respondent the right to have an accountant at one of the testimonies in an investigation. And what they did was they struck down the enforcement action in whole. They said that, look, you don't even get a do-over here because it was so infected from the day one. What you can do is have a whole new investigation, but this investigation and this proceeding is done.
Yeah, and you talk about kind of the taint of what happens when you don't give people access to, for example, an accountant in that case, or you don't necessarily impose rules of hearsay. You can't discreetly carve out that misdemeanor, if you will, in the proceeding and say, okay, we're going to ignore that, but the rest of the proceeding is okay, because as we know as litigators, and many of us around the table, all of us around the table are litigators, that's not how litigation works. And it's an interesting issue, and it's one that I think Lucia doesn't fully reconcile in its decision, and for good reason. I think the court needed to come to a consensus, and it couldn't go 100% of the way there. I want to change tacks a bit and talk a little bit more about litigation in the administrative arena, but not so much in the administrative agency forum as George and I were just discussing, but more what happens when you bring an Administrative Procedure Act challenge in either a federal district court or the D.C. Circuit. What are some of the practical considerations around that? And Moxie, I'm hoping that you can help us think through some of those issues and some of the concerns and questions that arise, and also some of those just practical strategic considerations that I think are necessarily part and parcel of any litigator's toolkit.
Sure. So some of you may or may not know some of the basics about challenging an agency action in federal courts. I'd like to go through those, but I also will address some of the specific issues I've seen that have been successful and that have been unsuccessful in challenging administrative action. So first question you have to ask yourself is where you're going to bring your challenge. Now, generally, this is set out for you by statute. If you can go straight to the Court of Appeals, most parties tend to go straight to the Court of Appeals, but more often than not, you'll find yourself in district court, and more often than not, when you're in district court, you'll find yourself in the U.S. District Court for the District of Columbia. Now, that is not a given, though. You can bring an agency action in other district courts or other courts of appeal, and that, I think a lot of parties tend to just by sheer momentum or inertia end up in the D.C. Circuit, but you should really, from the very beginning, even when you're in the agency, consider where you're going to bring your challenge if you lose. If you, like I said, some of it will just be dictated by statute, but the benefits of being in the D.C. Circuit or in the U.S. District Court for the District of Columbia is that you have both district court judges and Court of Appeals judges that are so steeped in administrative law. They understand the process. They understand how an agency rule is promulgated, and understand how administrative proceeding kind of goes about, how it goes about, about the process and administrative level. But that could end up working to your detriment if you're trying to bring a novel legal theory. And there are some, and seeing the trends in the district court and the D.C. Circuit, those judges are coming to an administrative case with standards that they could probably recite in their sleep. If you have a challenge that you possibly want the court to think outside of the established standards and established rules, you may want to consider whether there's another forum for you to bring your challenge. And like I said, on the flip side, if you want a court to strike down a clearly egregious violation of the administrative process, you're going to go to the D.C. Circuit because they understand and they can act swiftly. The benefits of being in the D.C. Circuit is that you're going to get a much quicker adjudication than you are in the D.C. District Court. There are parties who are challenging agency actions that may be worth billions of dollars, something that regulates a particular arm of the financial markets. Well, most D.C. District Court judges will tell you that every single one of their cases affects billions of dollars of the market. And so I have seen, in one case in particular, a potential party that had activated members of the market. Part of the street was involved. They were calling chambers, telling chambers how important the case was. And the district court said, look, get in line. And so if you want to be in a place where the case runs a little bit slower and that you maybe don't want an adjudication right away, you might want to be in the district court. Because the Court of Appeals will run very quickly. there's a very, very narrow class of cases where you have a choice, and for those you want to give that some consideration. Obviously, if you have a case dealing with the SEC, the CFTC, or some other financial cases, you may want to consider whether the Second Circuit is the place you want to be, because that court obviously has particular expertise in financial markets. Now, the next question is when is the right time to bring your challenge? As we'll get to in a minute, there are certain rules that apply to administrative challenges there's certain rules that apply to typical civil cases that don't apply to administrative challenges. For example, you do not have to do the normal meet and confer meeting where you go through what a discovery schedule might be, because there is no discovery in administrative cases. Put an asterisk on that. I'll get back to that in a minute. And there are, basically it's going to go from your complaint to your summary judgment brief. Now, depending on what court you have and what else they have on that court has on its docket, you may find that it may be 5 months to summary judgment, or you may be a year and a half, 2 years down the line, and you're still briefing your summary judgment briefs, as I am in a couple of my agency actions right now in the district court in D.C. But if you need swift adjudication, there's a particular rule that's going to go into effect that will cause irreparable harm, then the quickest way for you to get an adjudication is to combine your APA challenge with a petition for a temporary restraining order or preliminary injunction. Why do I say that? Because more often than not, if you can make the case for it, a court is not going to want to do briefing on your emergency motion and on the merits of the case separately when it doesn't have to. And you can make a case for getting your TRO or preliminary injunction petition combined with the adjudication on the merits. So you're going to end up filing what's called a motion for a preliminary injunction and summary judgment, and try to just get a final adjudication. We had one case in which a rule was going to go into effect that was actually going to change, really was going to change a billion-dollar market. And so the court allowed the parties, on one side was the agency, of course, and on the other side were a number of institutional investors. And they combined their petition for a preliminary injunction with a motion for summary judgment. All the briefing was done within a month or two, and the court was able to rule, and the court ruled right before the rule went into effect, and the court struck down the rule.
So I want to ask you a question as a litigator, Moxie. One of the things I think we often struggle with when we handle APA cases, and I've struggled with it, is it's almost a quasi, or it is almost an appellate case insofar as you're really looking at the administrative record through the prism of a district court, to the extent you're in district court. And one of the issues that I think is you're always mindful of is how do you put in front of the judge in district court, especially. So a trial, a judge who's used to trials and who's used to making credibility determinations about parties. And so much of these things, no matter who you are, where you are, what you do, comes down to that question. You can use the preliminary injunction proceeding to try to get in front of the judge a witness. If you're lucky enough to get that rule, it's not a given in the District of D.C., at least, that a preliminary injunction hearing in an APA case lets you bring a witness on and put a witness on. But how do you humanize your clients? How do you make it so that it's very clear to this judge that this isn't just a question of a rule not being right or a decision not being in accords with an interpretation, but that this is a bunch of people or individuals or entities that have real skin in the game, and if we get this wrong, they go out of business, or something serious like that. Because I think at the end of the day, that's always the challenge when you litigate, period, but especially when you litigate something like an APA case, where there's so much evidence in favor of an agency, and often those cases are like jogging uphill with a boulder on your back. How do you manage that?
Well, the best way to do it is if you have grounds for a TRO or PI, you can get someone out there. It's not going to go it's not going to go towards the merits of your case, but you've got to show that you're going to be irreparably harmed. And one of the most deft ways that I've seen it handled in person was when there was a party that said, look, our entire market, our entire business model is going to be changed, and you have, this many number of dollars on the line. It's like a number that I'd never even seen before in my life, never contemplated before, and you put, and you're able to get in front of the judge, get in front of the court, the mechanics of the market and what it means to the market. It's crucial that you do that because generally administrative actions, can be, depending on what they are, can be. The court sometimes considers them they're a little bit drier because they don't have the personalities involved and people involved. But hopefully, if you've done your work right and you had a concerted strategy from the time that you were in the agency, you potentially even have put in testimony at the agency level of who your witnesses are, what their business is about, what they're going through, and what they're facing, and then you just have this wonderful prepackaged testimony that you can put in front of the court if you don't have grounds for a preliminary injunction. You've got to be thinking about, just as a trial lawyer will always say, that you've got to be thinking about appeal. At the agency level, you have to be thinking about what this is going to look like when you're in the district court or the court of appeals, because you're largely going to be stuck with that.
Yeah, and preserving your record. So a few other thoughts on that. One of the quagmires that I think regulated entities often find themselves in when they're considering an agency challenge is, you're going up against the agency that regulates you. And there's all kinds of reasons why that can be a risk. And, the juice has to really be worth the squeeze, so to speak, in order to do it and to go into court and bring an APA case, especially if that is a relatively high-profile matter. Sometimes you're talking about issues that are fairly not high profile, they're very industry specific, and they're covered in a very narrow way, not in a general media way, but sometimes you're dealing with matters that are quite high profile. And you're going into court, you're challenging the work of an agency that is your primary regulator. And that's a real, that can be a huge issue and a real Hail Mary sometimes. How do you counsel clients about that? I'm curious what your thoughts are, Moxie. I'm curious what your thoughts are, John, about these issues and just thinking through not only the mechanics of the litigation, but the kind of first threshold question, do we even do this?
Right. Well, it's a really important question. I would say bring your challenge when it is likely to succeed or that you have a really good case. And of course, you want to be, again, thinking about that at the agency level. And what's the idiom about shooting the king? You want to make sure you kill him or her or the queen. Look, there are some rules that are so crucial to the markets or to your business that you absolutely have to bring the challenge. But you have to be willing to live with the fact that you're not going to be able to present this new case to the Court of Appeals or to the district court. So if you have not put your best foot forward as agency, you have to live with that. And I think more often than not, there's this rush to challenge a rule. I think you do have to think twice and only bring the cases that, number one, if unchallenged, would completely change your business model or completely change your business, and that it would be a detriment to your business. And number two, the case that you actually have a chance of changing the law, extending the law. If you're within your business and within your lawyer's estimation, you have a 20% chance of winning, you may still want to take that risk. But I would say, you've got to live with this regulator for a really long time.
And you just have to live with the fallout from it. It's sometimes a big deal, and it's a huge issue for people to make that decision. And you don't have, I should also add, you don't have a ton of time to think about it. You really have to Moxie's point, start thinking about a potential APA challenge while you're in the middle of whatever process is going to be susceptible to that challenge, whether it's an agency determination about your status or it's a particular rule that's being drafted. You really need to be thinking as you're going through the motions of writing a comment or making objections to whomever the decision maker is, what is this going to look like in a court? And this is it. This is your record, because you don't get to take, Rule 26 discovery or put on the stand 5 witnesses and elicit from them lots of interesting things that maybe enhance your record. How do you counsel clients in this space, John, on those issues?
Well, Moxie has hit the nail on the head. I'll give a couple of examples to make it more practical. One is those of you on the phone who work in trade associations understand it's one of the reasons trade associations exist is to bring litigation like this. Nobody wants to be the named plaintiff on a complaint that challenges an agency rule, which they're afraid is the functional equivalent of standing in the middle of an open field holding a lightning rod in your hand. And even within trade associations, one of the biggest dynamics is the divergence between the views of people who really want to challenge a rule and those who are concerned that if they bring it, the agency will become more hostile, or even worse, they bring it and lose, in which case the agency's hostility is guaranteed. So that's just one of the many manifestations as to how the litigation risk has to factor into every decision you make at that point, and who will be selected as the plaintiff, if anybody, for fear of retaliation. And the second way to make this point is for those of you on the phone who are in financial institutions, and especially ones that are regulated by federal depository insurer groups. Think about how many cases there are that have ever challenged the agency's determination of what safety and soundness means. There are just a handful of those because nobody wants to bring a case against somebody who controls your ticket to do business and has 100 other ways of making you wish that you hadn't sued them, especially in something as broad as what safety and soundness means. So this is a predominant thought. It's one of the ones that takes up most of our time talking with clients, especially trade association clients, unless, as Moxie points out, that there's something there that crosses such a red line that it's going to be fatal to the existence or the profitability of many people in the industry, and really you have no other choice. But the agencies do a good job in their due diligence of figuring out where the fault lines are within trade association groups or within industries and trying to avoid crossing those red lines and uniting everybody in the industry against them. They much prefer to play the traditional divide and conquer game. So every time you go in to present your case to an agency, they'll be listening for where the fault lines within your coalition might lie.
And you see that especially when you're talking about rulemaking in industry that rule would have a very material impact in, where it may not be a one-size-fits-all for the entire trade association coalition, and there actually may be factions who support it or don't support it. I think that dealing with those issues and thinking through those strategic points is mission critical. The decision to sue an agency in court is no easy thing, and it's no easy task, and it is an uphill battle. We win them. Our team has won those cases, but there are cases that you bring. And as Moxie said, it's like target practice. You get one aim at the target, and you better hit the target in the bullseye or else. And so it is a very clinical thing. And I suspect, and you both can correct me if I'm wrong, but I suspect when you make these arguments, you also craft them in as narrow a way as possible to avoid, kind of a backlash from agencies, and also to kind of make sure that the right arguments are in front of the court. I don't know if that is your thoughts on that, John.
Well, yes, I'll pass it to Moxie in a second. It was more immediate practical experience with this. But the general rule is that you always look for the moral high ground if you can find it. And you have an involuntary relationship with your regulator. The day after the lawsuit is over, you're going to see them back in the supervisors are going to be back in looking at your documents again. You can't afford to alienate them because it is an involuntary but permanent relationship. And you always have to take that into account in expressing your arguments.
I couldn't agree more. And so that's why I kind of come back to this, concept of you may not necessarily you may want to start by looking at whether or not there was just perhaps an innocent but erroneous interpretation of the law, and questions that you raised that you can raise again on the district court, ones that you actually raised to the agency and that the agency either declined to rule on or that ruled against you, ones that you gave the agency a fair opportunity to do the right thing, and the agency didn't. It's always a very gentle balancing act, but you don't necessarily want to come into the district court with a completely new theory that you never gave the agency an opportunity to rule on, because that's a surefire way to lose and to raise the hostility of the agency even further. In a perfect world, the agency's not going to be hostile, and they're going to say, oh, this is just how it works, but I've yet to see that happen.
So I want to, again, talk about litigation and challenging agency decision-making, but from a slightly different vantage point, considering agency guidance and its own rulemaking and interpretation of its enabling act, et cetera. And Samir, I'm hoping you can walk us through kind of how this stands right now in the courts. There's a lot of debate going on about to what extent courts should continue to give a fair amount of deference to an agency's own interpretation of its rules, which of course are designed to implement its laws, its statutes. And that's actually probably, of all the things we talk about today, the topic that is most substantially contested and debated right now, because there is a movement afoot among judges to reconsider the efficacy of what we call the Chevron doctrine. And so hopefully you can walk us through what's going on with that, maybe give us a bit of an explanation as to what the Chevron doctrine is in theory as well as in practice, because I actually think there's a difference between how it's applied and how it's supposed to be applied, and what we should be expecting in the future.
Thank you, Alison. Yes, certainly the Chevron doctrine has no shortage of critics. As we're talking about the Chevron doctrine, I wanted to sort of take a step back and think about it in terms of what Moxie spoke about, and how the Chevron doctrine is very much essential to litigation challenges and considerations in the APA sphere. If you're like me and your email inbox is inundated with legal newsletters that usually have very catchy titles, you might be led to believe that the administrative state and agency deference under Chevron is going the way of Atlantis. But the fact of the matter, and as I'll discuss in my portion of the webinar, the statistics that have been carried out through empirical studies as well as recent jurisprudence don't bear out that narrative. So as we're sort of thinking about the Chevron doctrine, I wanted to sort of, again, to Alison's point, be very clear on what the Chevron doctrine is, because it is one that is thrown out in colloquy and in our everyday language to mean generally deference to an agency. But in fact, the Chevron doctrine is this principle of administrative law that conscribes a framework for which courts can analyze or assess agency actions. And on the basis of that, apply a two-step framework to decide whether or not deference should be given to the reasonable interpretation of an agency where the statute is within the purview of that agency. So that is to say, a long story short, deference can be given to an agency so long as Congress actually or implicitly or explicitly endowed the courts with that ability to look at whether or not the agency interpretation should be given deference. If the intent, as the step one of Chevron makes clear, if the intent of Congress is clear, then that is the end of the analysis. We should, in fact, do as Congress has wished. The step two, if the language is ambiguous, then and only then do we actually look at the agency's interpretation. And the agency's interpretation will be upheld provided it is reasonable. This provided is reasonable operative language has really been the core of what a lot of recent opinions have come before the court, and where courts have sort of construed the language in different ways. This year alone, the Supreme Court has either mentioned or discussed the Chevron doctrine in 6 occasions, which again goes to the point that the Chevron doctrine is back in vogue. It's very popular in the courts, as well as an understanding that the Chevron doctrine is being revisited for multiple reasons. One of the things that Chevron doctrine does that a lot of people don't think about, though, is the fact that the Chevron doctrine is premised on this idea that it is a judicially created doctrine, and it rests upon what we understand, or the presumption of legislative intent. Chevron is often criticized as being a court activism, a manifestation of judges willing their wishes upon the masses. But in fact, what we've seen in recent case law, especially Sessions v. DiMaio, a case I'll talk about later, in which Justice Gorsuch had a great influence, you see this criticism, in fact, of Congress's drafting of the language, and that vague language creates opportunity or opening for particular challenges. So no discussion of Chevron is complete without mentioning Auer. Auer v. Robbins, a case decided in 1997, is the rule-based corollary to the Chevron doctrine, and it makes clear that deference should be given to the interpretation of an agency's own regulation unless plainly erroneous or inconsistent with that regulation. Again, to the point of conflation between the Chevron and Auer, often people will refer to Auer as simply Chevron deference, but in fact, it is the rule-based analysis within the Chevron framework. The interesting story of Chevron is that its proponent at the outset, Justice Scalia, who authored the majority opinion Auer, was probably one of the first and most immediate individuals to openly critique or perhaps show some regret about how it created sort of perverse incentives for agencies to draft vague regulations. Now that's interesting because that again comes to the point of where Justice Gorsuch has come and filled that particular place and rendered his criticisms of Chevron and said that the problem with Chevron is not that Chevron creates powers or that it opens up potential challenges, but that in fact it gives an incentive to Congress to draft these sort of vague legislation provisions that sort of open the span or give agencies wiggle room that perhaps they shouldn't be given.
So, Samir, do you think that the revisiting of Chevron doctrine is animated by an interest in limiting so-called judicial activism, or do you think it's animated by an interest in making Congress be crystal clear and much more precise in its rendering of statutory language, or is it both?
I think it's a hybrid approach. It's a mixture of both. I think that there are those who see Chevron as an empowerment of the administrative state, and critics of the administrative state see Chevron as a vulnerability that in fact Chevron has created opportunities or reach that the administrative state didn't previously have. On the other end of the spectrum, there are many who would say that the Chevron doctrine made very much clear, it was a palpable lesson to Congress, you will reap what you sow, and that if you draft legislation that opens up various ambiguities, then the agencies will have that reach that perhaps you did not intend for them to have.
And at the end of the day, there is an ongoing concern about so-called agency overreach, or agencies exceeding the scope of their intended authority, either through their enabling act or some other conduct, the enabling act kind of being the scope, the outside boundaries of their authority. Are they operating within that? Are they operating as Congress might have intended, whatever that means? No one ever quite knows what that means, but it sounds like a lot of the skepticism, collective skepticism about the ongoing survival, if you will, of the Chevron doctrine comes from those issues. Things that are kind of themes of what we've been talking about today. How far out can an administrative agency go in making rules? Is it okay to try people in an administrative tribunal? Is it okay to pass rules that are so vague in their interpretation that they're susceptible to APA challenges? How much deference do we give to agencies if they say a rule is a rule this way? What does that actually mean? And then, of course, the flip side of all of this is what does it mean for the courts if they're going to be flooded with challenges? And I'm curious about your thoughts on all of those issues in some order, Samir.
No, sure. And certainly a lot that to answer. I think that ultimately what is telling are the statistics, and there are two actually article and study authors, one Cynthia Barmore and the other William Yateman, who have published articles in the last couple of years that have looked at these issues and what the impact is with respect to the circuit courts. And again, to a point that Moxie was making earlier, that the early on litigation decision of where you decide to bring the challenge may ultimately determine whether in fact you are successful. And the agency win rate between particular circuits is palpable and well understood. What we've seen, however, is that where courts are now taking the approach, and this is particularly true in the Seventh Circuit, where we're seeing where courts are looking for specific language, that are looking for particular issues and are less interested in sort of getting into the weeds of stepping between the agency and the legislation that empowers it, is that particular circuits are now looking at challenges from the lens of if there is truly a question that is on the national front, we are not going to interfere with Congress has intended, and we are going to allow agency deference to sort of promulgate and spread. So one of the points that we coming back to is whether or not the recent cases, and specifically I mentioned the 6 cases this year, as well as the recent articleship that would tend to indicate that agency deference is on the decline. What I will tell you, and a bit of a spoiler alert, my conclusion is no. That in fact, if you look at the history of agency adjudication, if you look at the history of agency deference in litigation, it more reflects that of an EKG than it does that of a decline. And right now we are seeing what's called a fade in statistics terms, and what that means basically is that courts are pruning away at what we see as the outer reaches of the Chevron doctrine. And what we're seeing is more interest in what has been known, and Alison sort of mentioned to this earlier, is the Skidmore deference, which is a lower standard of deference. It's this idea of giving weight to an agency's statutory interpretation so long as you look at a number or a litany of factors, and those factors include everything from the thoroughness that an agency undertakes when it decides to promulgate a rule, the thoroughness evident in the consideration around a legislation and how it was drafted, to the consistency, looking at how has the drafter treated similar rules or similar statutes, and whether you can look at those factors and it'll inform whether or not you should give some sort of deference. Now, something interesting is that Skidmore has come back also into vogue, and in 2017, Senator Bob Portman introduced a legislation called the Regulatory Accountability Act. And in that legislative solution, which has been sort of received well with bipartisan support, the rules, that is the rule corollary of our, would be replaced with Skidmore. That is to say that where agency interpretation of a rule that it promulgates should be given deference, there needs to be a number of considerations. Now, the considerations are far more than what Skidmore, and I'll give you an example. Everything from whether they published a notice, whether they provided notice to OIRA, whether they provided information to the public in a way that provided some sort of notice and comment. It imposes such a level of scrutiny on agencies such that agencies would be required to meet what's called a checklist solution. In order to meet that checklist, they would have to, one, produce the fact that they have met all of the requirements, and then be able to say that, you know what, we can go with our interpretation. At that point, is it really deferring to an interpretation or actually publicly making that interpretation known? And that's really been the debate. United States versus Meade was an interesting case, and I'll skip over a little bit of this. Much of this is to provide a little bit of background. But in 2015, there was a sort of watershed moment in the administrative law and Chevron doctrine sphere, and that was King v. Burwell. It pronounced something we now are long known as Chevron Step Zero, a phrase that was coined by Cass Sunstein. Chevron Step Zero is that idea that before we even get to Step 1 and Step 2 of the framework under Chevron, we have to ask ourselves a very simple question, and that is, what is the economic and political significance of the rule that is being interpreted? And this idea of a Chevron Step Zero is one that is right now being considered and being written about quite a bit by litigation scholars in the area of administrative law challenges. And this idea of how do we implement agency action from the legislative side is also being undertaken. So in conclusion, Chevron is not dead. Instead, courts are applying various glosses according to the need and circumstances. And this is this idea that courts will continue to criticize Chevron and will continue to say that it is the worst thing that has ever existed, but there is no better or palatable alternative. Even the Supreme Court's most vocal critics, Justice Thomas relied on Chevron in national telecommunications. Justice Scalia championed Chevron in City of Arlington. Even the most vocal critics of Chevron doctrine have at some point returned to the framework in order to justify their own reasoning. And there's a reason for that. The framework follows with a bipartisan understanding that ultimately agency promulgation, agency interpretation follows the public's will through voting and through representation. With that, I will say thank you, and I will pass the baton to John Cooney, who will speak to one such very vocal person in the area of administrative law who herself has opinions on Chevron doctrine.
So John is going to talk to us a bit about Naomi Rao, who is currently overseeing OIRA, where John also has worked and spent time, and has been nominated to take Justice Kavanaugh's place on the D.C. Circuit. And she, of course, is a true scholar of these issues, and is somebody whose opinions and thoughts will undoubtedly inform the way we think about the law for many years to come. So John, if you can kind of give us some thoughts on that, and maybe help us think a little bit about what the future of agency deference looks like.
Naomi is an interesting case. She is a total administrative law devotee. She was the founding director of the Center for the Study of Administrative Law at the Antonin Scalia Law School. By nature, she's very merits-focused and very practical in her approach. But by having focused on this since her days as a Supreme Court clerk, she has been a leading scholar in the limits of the constitutionality of the various steps that administrative agencies have taken. We really haven't seen anything like her appointment from somebody from OIRA who is going to the D.C. Circuit since former Chief Judge Ginsburg was appointed back in 1985. Now, Judge Ginsburg had been an antitrust scholar before he went to OIRA. And when he was at OIRA, he had 2 years of having his hands on all aspects of agency regulations over a period of time, from cost-benefit analyses down to statutory interpretations. And after his 2 terms at OIRA, 2 years at OIRA, he went back to the Justice Department to head the antitrust section, and from there went to the D.C. Circuit in 1985. So he had a mixture of intense administrative exposure in an agency, plus 2 years at OIRA. Naomi is a little bit different. She has had a career in the administrative space, and then she had 2 years where she also was inside every rule that an agency wanted to submit to the White House for review, and worked with White House people to question every aspect of the technical support for the rule and the policy justification for the rule. And now that she has been appointed to a court that has as its function essentially these days the determination of administrative cases, she projects to be a leading scholar, a scholar in residence on the D.C. Circuit for the next X number of years as to what are permissible boundaries on the administrative agencies. And I think that if confirmed, she'll emerge as one of the most influential lower court judges in helping the Supreme Court think through administrative issues as they come up, because they've known her as a colleague when they were all younger and working on theories of the administrative state. But unlike them, she will have had her hands on every aspect of those rules and will be able to get down to the nuts and the bolts better than the people who are extremely smart generalists who've had to pick up administrative law on the fly on the Supreme Court.
John, can you tell us a little bit about OIRA, what kind of office it is, why it's so significant to the administrative state, for those on the phone who may not be as familiar with it?
Most people misinterpret what OIRA is. Most people think of OIRA as a standalone agency that has its own authority, but it's really not. OIRA is a metonymy, if I can remember the figure of speech that our high school English teachers tried to teach us. OIRA is the situation where a part is representing the whole. The whole in this case is the policy decisions of the White House as to what rules the administration should back and what principles it should follow and what policies would be good for the country. OIRA is the career staff of the White House process. It's like the OMB budget examiners, and the OMB is influential in appropriations because it is the only part of the White House process that has a career staff. It's the only place that can go down into the details. Without the budget examiners advising the White House about what the implications of budget decisions were, the White House would go off track. OIRA is the same way. It is the career staff. The head of OIRA is the person who comes into White House policy meetings, who actually knows the details of what's at stake and can speak to the people who come from a political and policy background. One last thing about Naomi, which is significant for many people on the phone. As the slide shows, Justice Kavanaugh quoted from her scholarship twice in the PHH case. Naomi in particular is somebody who's thought long and hard about presidential oversight of independent regulatory agencies and how that relationship could work. When Naomi was appointed to OIRA 2 years ago, it was taken as a signal by most of the experts in the administrative space that the Trump administration was prepared to take some kind of initiative to try to extend presidential power to the independent regulatory agencies. There were any number of options on the table as to how broad the president's exercise of authority could be and which approach he would take. But with Naomi there, it was thought that it was likely that this president might have the courage to try. Each of his recent predecessors had understood the options, but had made the determination that it was not worth the political capital for the president to try to expand his reach to include the independent regulatory commissions. And this hasn't happened in the first 2 years of President Trump's administration. So there's a large question mark now as to whether this is ever going to happen, or whether he also has made the determination that it's not worthwhile trying to reach out and bear the political crisis there would be if he tried to exert authority over the CFPB, the SEC, the FTC, et cetera.
But the legacy of her thinking will be with us for many years, assuming there's no reason to think she won't be confirmed on the D.C. Circuit. She's certainly eminently qualified. And what we'll see is this interest in perhaps reining in a bit some of the administrative agencies, whatever that means. That idea will continue to percolate past the Trump administration, don't you think?
It certainly will. I mean, really the issue has just been joined now. There is a consensus in the Supreme Court that Chevron constitutes a violation of the separation of powers doctrine because the agencies are now determining what the law is, a classic Supreme Court function. But nobody has come up with an alternative that could serve in place of Chevron and to recognize some role for the administrative agencies in the interpretation of law. And until that problem is solved, until someone comes up with a remedy that has the support of 5 justices, Chevron is going to continue to stumble on, I think.
Thank you very much. That's a great way to end our presentation today. I want to thank all of our fantastic panelists, John, Moxie, George, Samir, and I'm Alison Baker. Thank you again for joining us this afternoon. This entire presentation will be available shortly on Venable's website as well. Please feel free to reach out if you have any other questions that we did not answer during the presentation today. Thanks again.